Ladies and gentlemen, foreperson of the grand jury has the jury reached a verdict?
Yes, sir.
All right. If you'll hand that verdict to my bailiff. And before I read the verdict, is this verdict unanimous for all 12 jurors? All right. I'll ask the defendant and his counsel to please rise. I want to caution everyone again, there will be no outburst. It's inappropriate for any parties, counsel, anyone else in the courtroom to react in any way to the verdict. So I'm looking back on page 11. We, the jury, find the defendant guilty of first-degree manslaughter under instruction number 6, signed by the foreperson. Again, let me ask you, foreperson, did I read that correctly, and is that all 12 jurors agree with that verdict?
Yes, sir.
All right. You may please be seated. Counsel, if anyone would like to review the verdict form and or poll the jury from either counsel? No, sir.
No, Your Honor.
Anyone? All right, if you all would approach.
I cannot wait to have this conversation because still with us, trial attorney Wendy Patrick. Wendy, before we get to you, let me just weigh in with you on our emotional reaction to this verdict and your thoughts, Michael.
Well, you look at it this way, it was a huge victory for the defense. This is what they wanted. But I am struggling with the facts of this case and jibing that with this jury's verdict. I mean, they're sitting there, they're in the courtroom. You have to respect that, and I certainly do. But the way this went down, I didn't feel like they had proven that there was this extreme emotional disturbance. He seemed very calm and making decisions very clearly. I think other witnesses testified to that as well. There didn't seem to be this extreme emotional disturbance. Judge didn't buy it, but the jury did.
And that's what I want to ask Wendy about as well. I don't disagree with you, Michael. And Wendy, the difference between murder, which was the premeditated murder, versus what he's convicted of, the manslaughter, showing that really they bought his story on the stand, that he had been physically and emotionally abused by his wife. He just snapped. He did this. What are your thoughts, Wendy Patrick?
My thoughts are they either bought that or they didn't think that the case had been proven beyond a reasonable doubt, that that couldn't have been the way it went down. And I say that having faced many of these types of cases where you have what some jurors believe is a very sympathetic set of facts, whether or not they know exactly if it's 100% true. Remember, one of the things that complicates mental defenses, and I'll speak broadly about that, is they're looking at this defendant in the courtroom. He's not evidence, but they have to see him day after day, and he becomes humanized to some extent, particularly when there's any emotion from that counsel table. They know they're not allowed to consider that, Ashley and Michael, and they're told by the judge they're not allowed to consider that. But as human beings, they do. And not necessarily to say we believe everything he said, we believe everything that's been presented on his behalf regarding the emotional demeanor and the provocation. But they use it back in the deliberation room often to say, we just can't say beyond a reasonable doubt that couldn't be an alternate reasonable explanation of the evidence.
Yeah, he took the stand. I guess they bought his testimony. You and I didn't necessarily buy it. I didn't think he covered himself in glory, but obviously they must have bought it. Stand by, Wendy, because I understand that the judge is actually addressing the court. Let's go back in.
Ladies and gentlemen of the jury, in the Commonwealth of Kentucky, we would go right to the sentencing phase of the trial, okay? I've had that discussion with the attorneys concerning witnesses that they would put on. Now, what I mean about that is we have what's called truth in sentencing. Part of that truth in sentencing is understanding, first from the Commonwealth, it's a mini trial. Commonwealth can do an opening, they don't have to. Defense can do an opening, they don't have to. They will hear some evidence just like we did last time for the sentencing portion of the case. Truth in sentencing means most likely from the Commonwealth you will hear from a probation and parole officer that will tell you the time that you can give for this charge, how much percentage of that before a person's up for parole, things of that nature. And then also you can hear impact information. You can hear mitigating testimony from the defendant. There is going to be some testimony to that. Being as it is late in the day, here's what I would ask you to do. It's going to be my call, all right? I want to make sure you know it'll be my call in discussing it with the attorneys. Here's what I would ask you to do, and the attorneys are in agreement with that, because there is a ability to not be sequestered after the verdict is in, but again, that's my call. Here's what I would ask of you. Why don't I return you back? You all discussed amongst yourselves, okay? Someone might have something this evening, 4 things to not be able to stay longer, but then some people may have something tomorrow morning, because what we would do if we didn't stay and get it all done today, we'd come back tomorrow for the sentencing portion of the case. So I want to give you 5 or 10 minutes to go back, discuss, and I would ask that the foreperson let me know when they're ready. Probably just send a note out. Don't just send a note out what the jury would request. I'll bring it in front of the attorneys and we'll have discussion on it, okay? Let's do that. Give you about 5 or 10 minutes. When the foreperson's ready, just give that note to the bail. Thank you. Please rise.
Okay, so you heard the judge there essentially telling this court now in Kentucky, they usually would go right into the sentencing phase. But the jury had the option of whether they wanted to stick around and do it or some other options as well, because what he was going to do, he was going to sequester this jury until they came up with a verdict. So the question is, will they be sequestered if they start tomorrow? Do they want to continue on with it today? So they'll come back with their decision in just a bit. But let's bring back in our guest still with us, trial attorney Wendy Patrick. And Wendy, what's interesting about this, I thought one of the biggest hurdles in this case, and why don't we call up the video of the shooting first, and then I'll address this to you. Let's take a look at what's at the center of this case, the shooting of this victim, Ashley Henning. All right, there's no doubt that that's devastating video, right? And you're looking at the defendant there, very emotional. Again, a big win for the defense. But Wendy, one of the biggest issues I thought was where he shoots her. Then he goes back and reloads the gun and comes back. Now, he's making some grunting noises that you could suggest maybe there's some weird going on in his brain. But I thought doing that, and I thought the defense really came up with a great way to explain that, saying that he was a military man and that they're trained to do this. It's like muscle memory, and that's just something he did in this weird state. So I want to give kudos where kudos are due, even though I don't agree with the verdict. I thought that was ingenious, the way the defense approached that.
You know, Michael, that's such a great observation you made. You know, that video never gets easier to watch. Can you imagine how triggering that is for the jurors, for those men and women watching that? Sometimes without a personal frame of reference as to how in the world someone could be emotionally provoked to do something like that, they will be receptive to hearing alternate explanations, because that would at least make it easier to understand how in the world somebody like this could kill their spouse. And, you know, we have the same dynamics going on in jury rooms as we cover these cases, you know, all over the country, where jurors want to have an explanation for such tragic behavior for everyone involved. And Michael, I think you're absolutely right, is you do have these defenses, if you will, whether they mitigate the offense, as in this case, or whether they're supposed to be a complete defense. We've all had experts that get on the stand and say something we can't believe a jury would buy, yet they do, or as I was saying before, they can't rule it out beyond a reasonable doubt that there was something that led him to sort of default to this military type state where he would be able to do that, Michael, and then go and reload and go and shoot again.
You know, the part that bothers me, though, is not on the video, but we know there was testimony that he then went and spit on her after he shot her. And that's
right.
Where I struggle with, oh, really, you do that when you're in this emotional state? Anyways, I want to just ask you quickly about the sentencing. The win for the defense, I think, is because the first-degree manslaughter carries 10 to 20 years, and you can be eligible for parole after serving 85%, versus a number of different options. But had he been convicted at murder, he was looking at the death penalty not on the table, but therefore he was looking at the extreme of life without parole, perhaps as few as 20 years, not likely. What do you think?
I'll tell you, I think that one of the things that will mitigate this case, obviously, is because the jury found the way they did. And it doesn't necessarily mean, well, now we're going to give him the high end of what he otherwise would have gotten. But I also do think that there's going to be an issue of, you know, does the punishment fit the crime? And this is a very serious crime, especially given, Ashley, as you pointed out, and I noticed the same thing. There was more than just emotional contagion, if you will. There was also this element of, whether you want to call it disgust or contempt, those emotions were mixed in there as well. And that may very well factor into the decision as to what he deserves now as a result of this conviction.
Yeah. I gotta say, Judge, what really bothers me about this case is that the problems in their marriage didn't seem to be that much different than a lot of people would have in their marriage.
So you don't get to go shoot and kill them.
And right, you know, it's kind of this weird space where maybe it affected them in a weird way, but it's almost like giving license to say, okay, I got a bad marriage, things aren't going well, so shooting them, I could get away with 20 years.
Because I snapped because of that.
Worst case scenario.
I'm having a hard time with it, but again, the jury has decided. We also are waiting to hear, and we're going to take a quick break while we wait, what the jury decides to do about sentencing. Will they begin today or tomorrow? Stay tuned. We'll get you back inside after a break.